Application of Cardozo's methods by Cole, Ashley, Caitlin, and Jason.
Cardozo's method of philosophy is where a judge applies the Constitution or statute to a case and ensures justice and logic are upheld.
The method of sociology is what Cardozo claims dominates the other three methods. According to Cardozo, the method of sociology is utilized when a judge must fill in the gaps of the written law. Additionally, when a judicial process in which a religious, ethical, or social sense that could create much conflict occurs, it would be wrong of the judge to go against their own personal experiences and beliefs when making a ruling.
Cardozo describes the method of history as predominantly an investigation of the origins of laws. He limits it to clarifying a problem in law rather than solving it. It seems that Cardozo does not advocate this method, but does realize its importance. When it comes to tradition, he says, it is not so much for the creation of new laws, but for the tests that are to determine how established laws apply.
The fourth method, adherence to the precedent, the subconscious element in the judicial process, focuses on how the judge's decisions and ultimately the laws should change with time and society. This theory establishes that there is no clear-cut line of guidance and law, and that a judge must create his own with his best discretion and practices. Blackmun seems to uphold adherence to the precedent throughout his dissent against the majority in Bowers v. Hardwick by focusing on how laws should change within society and decisions should not be made solely on the past and personal prejudices, specifically religion and deciding against sodomy and homosexuality. In Roe v. Wade, Blackmun also seems to uphold this method, but only to an extent. In this case, the first trimester, and the main focus being on the rights of the mother's privacy. However, after this point, he denounces this and relies more on sociology and the overall well-being of the child, allowing for the state to intervene with the rights to abortion for the sake of the unborn child.
In 2015, a case involving same-sex marriage was brought to the Supreme Court. The plaintiffs were 14 same-sex couples, Obergefell being one of them. Hodges is the director of the Ohio Department of Health. Ohio, Michigan, Kentucky, and Tennessee defined marriage as a union between one man and one woman and did not recognize same-sex marriages. The plaintiffs challenged these laws under the 14th Amendment. Two questions were brought to light. 1. Do same-sex couples have the right to marry in every state? And 2. Must the states recognize same-sex marriages that have been licensed and performed lawfully out of state? The court voted 5-4 that both of these questions be answered yes under the 14th Amendment's Due Process Clause and Equal Protections Clause. The dissent came from 4 justices, Justice Roberts, Scalia, Thomas, and Alito. Chief Justice Roberts began his dissent by stating that this court is not a legislature. Whether same-sex marriage is good should be of no concern to us. Judges have the power to say what the law is, not what it should be. He goes on to say, understand well what this dissent is about. It is not about whether, in my judgment, the institution of marriage should be changed to include same-sex couples. It is instead about whether, in our democratic republic, that decisions should rest with the people acting through their elected representatives or with 5 lawyers. Scalia adds to that these lawyers are hardly a representation of America. This court consists of only 9 men and women, all of them studied at Harvard or Yale. 4 of the 9 are natives of New York. 8 of them are from either the West Coast or the East Coast, and only 1 of them from the area in between. Both Justices Thomas and Alito follow the same calls for dissent, adding that this decision will have inestimable consequences for our Constitution and our society. It is clear that these 4 justices attacked Cardozo's method that justices are considered legislators.
Schenck v. United States is a case analyzing the Espionage Act concerning the military draft. This case regarded a group of individuals who were distributing leaflets to draft-age men, encouraging them to resist the draft. Justice Oliver Wendell Holmes spoke as the majority opinion, stating that individuals who spoke out against the draft were subject to criminal proceedings. Debs v. New York is a similar case in which individuals were speaking out against World War I. Justice Oliver Wendell Holmes again spoke in the majority of the opinion, stating that once the individuals who were speaking out against the war were not protected under First Amendment freedom of speech and also subject to criminal proceedings. In Gitlow versus New York, another case in which the freedom of speech in speaking out against the government was brought into question. In this case, the defendants were convicted of anarchy, but Justice Oliver Wendell Holmes spoke in his dissenting opinion that in this case individuals are not making any attempt to overthrow the government. In the other two cases, individuals were speaking out against the military draft in the war, encouraging others to break the law, where in this case the defendants were simply writing or making statements regarding their discontentment of the Espionage Act.